So I am John Burroughs. I'm senior analyst with the Lawyers Committee on Nuclear Policy. I'm going to moderate the second half of this webinar. Just a reminder, if you have comments, interesting websites and the like, put that in the chat. If you have questions, put it in the Q&A. There's been some confusion between the two functions in the first half. So we've had to do a bit of reshuffling of the time, and we're going to start out now with Alyn Ware. He's going to talk about the World Court Project. Alyn was executive director of Lawyers Committee on Nuclear Policy in the 1990s and was a central player in the World Court Project. He's currently, among other things, global coordinator for parliamentarians for nuclear nonproliferation and disarmament. Go ahead, Alyn.
Thank you very much, John, and let me say what an honor it is to be on this panel with such incredible lawyers who have made such a huge difference in the use of law to advance human rights, peace, justice, and disarmament. I'm one of the non-lawyers that Peter Weiss was talking about who got inspired to become engaged in law because as a political activist from New Zealand working on nuclear abolition issues, I could see how valuable law could be to assist political process. And so I got involved in the World Court Project, and I'll give a little bit of an overview of what that was. So what I'm going to be talking about in this presentation is the World Court Project on nuclear weapons and international law, which was the civil society campaign to help get the case to the court, then to work with the lawyers and the government to win the case, and then to follow up after the decision from the court on implementing the decision. So I'm going to talk briefly about those three things. In the interest of time, I'll have to go a little faster through some of this and leave a couple of things out. There's a lot more to the story than I've got time to fit in 8 minutes. But getting to the court first, the origins. So this probably dates back to when nuclear weapons were first used against Hiroshima and Nagasaki, and the illegality of them, as written in Jackie Cabasso's article, nuclear weapons have always been illegal and in violation of the law, but how to bring that into reality. This is why legal opinions is very important, and the Shaw McBride appeal, getting 11,000 lawyers to endorse the argument that the threat or use of nuclear weapons is illegal was an incredible development. So too was the London Nuclear Warfare Tribunal in 1985, which was like a mock case of putting nuclear weapons on trial. This all helped many other things, and I can't go through them all, to build up the legal arguments and also the understanding that the legal arguments against nuclear weapons are very strong, which could give rise to taking the issue to the International Court of Justice. And the idea and advisory opinion actually came from the Lawyers Committee on Nuclear Policy and then ILANA. And there had been a few attempts in the 1980s to encourage governments, but none of them had picked up that idea and introduced a resolution at the General Assembly or somewhere else to take the case. What stimulated it was the dispute between the United States and New Zealand, my country, when we decided that we're an ally of the United States under an agreement, a military arrangement, ANZUS treaty, and we decided we wanted to ban nuclear weapons, which included not allowing US nuclear warships into our harbors. The United States opposed this, said we couldn't do it under the ANZUS treaty, and we were looking at how to keep our policy and turn it into a sustainable legislation. And we had the suggestion from Richard Falk, who was a board member of the Lawyers Committee on Nuclear Policy, that maybe New Zealand should look at taking this case to the International Court of Justice through an advisory opinion approach. We took this to David Longley, the Prime Minister, and he said, look, it would just be politically suicide. At the moment, we're struggling to survive, and all we're doing is saying that we're banning nuclear weapons from our own country. To take this into the international stage would be too much. you need to build up support from other countries for New Zealand to come on board. So that stimulated Harold Evans, a lawyer, Kate Jews, who was Vice President of the International Peace Bureau, and Eric Geiringer from International Physicians for the Prevention of Nuclear War, to suggest to those organisations, to propose that they come together to form the World Court Project, so that there'll be a big civil society campaign to help build support from the governments. And it was launched in 1992, the World Court Project. More background is in those couple of books, that I've put on here, if you're interested in reading some more of the background to it. So once there was a decision, yes, civil society wants to support lawyers in getting this case to the court, is how do you get there? We looked at 3 different bodies: UNICEF, the World Health Organization, and the UN General Assembly, and basically took the initiative to both the World Health Organization and the UN General Assembly. And then in terms of building civil society support, we invited organizations around the world to join the campaign. Over 700 joined, and then those organizations were instrumental when we had the resolutions in the World Health Assembly and in the UN General Assembly. We called on them to encourage their governments to support. In addition to that, we engaged citizens with something called declarations of public conscience. There are over 4 million of them signed. Here we see boxes of them being presented in front of the court by one of the leaders of this initiative, George Fairbrother. So very quickly, the World Health Assembly request, and I pay a tribute here to Hilda Leni, who was the Minister of Health of Vanuatu, who was one of the leaders of getting this successful resolution adopted by the World Health Assembly in 1993, taking the question of the use of nuclear weapons to the International Court of Justice. Unfortunately, the court turned down that request, saying it wasn't in the mandate of the World Health Organization to ask a legal question about nuclear weapons. But that was really important because the World Health request meant that a lot of evidence was presented to the judges anyway, and that was very, very helpful in the case which did proceed, which was on the UN General Assembly. And Hilda sent a message here for this event today, the 25th anniversary. I don't have time to read it out, unfortunately, but we can make it available afterwards. So the UNGA was important to get through. It came after the World Health Assembly. It was important. If we'd only relied on the World Health Assembly, we would have lost the case. So the UN General Assembly was very, very important. In order to succeed, it was tough. We had to set up a hub at the UN, and the Lawyers Committee on Nuclear Policy served as the hub to monitor what was happening, to work with the delegations to the UN on draft resolution, and then to feed back to the supporting organizations around the world progress reports. But just as important was lobbying in the capitals. We wouldn't have got the governments to support if we'd only talked to the ambassadors in New York or their ambassadors in Geneva. So I spent a lot of time flying around the world, going to both capitals and to heads of state meetings, Non-Aligned Movement, Pacific Islands Forum, etc. We lost the first year. Even though we had the Non-Aligned Movement on board, the lobbying power of the nuclear-armed states was so powerful that they got the Non-Aligned Movement to withdraw the resolution. We came back strengthened the second year and got it through in 1994. It was a huge campaign, a lot of work, but we managed to get it through. The next part is actually winning the case. I'm not going to spend much time on this, but there's 3 key factors to ensure that you do win the case. 1, the law, of course, the most important, and having the legal experts was vital. And Ilana provided legal expertise, which many governments use. So too important is the facts and the evidence, because the court applies the law to the facts and the evidence. So there are many ways that we were getting evidence of the impact of low-yield nuclear weapons would still be indiscriminate, for example. The long-term effect of nuclear weapons, which really came from the impact of the nuclear testing, witnesses from the Pacific, which was very important on the nuclear testing. I think it was a testimony of the Marshall Islands, which brought about, the affirmation of the court that the destructive power of nuclear weapons cannot be contained in either space or time, which I think is one of the most important parts of the court. The third part is political framing. And that was really important to ensure that the judges would perceive this as an important issue, and that the abolition of nuclear weapons, the prohibition, was something which majority of countries around the world supported. So we had to make sure we got a lot of countries to put written submissions into the court and turn up to the oral hearings. And one of the things with the oral hearings was we wanted to make sure we had the last word. And we had problems because when the list of countries for the oral hearings came out, the last 2 countries that were going to present, which would give a lasting impact on the court, was the UK and the USA. So we had less than 2 weeks to find a country in the alphabet that came after, which we did. We got them into court and we managed to have our opinion as the last opinion in the oral hearings, which I think had some impact as well. Finally, on implementing the decision, and I'll be very, very brief because I think I've nearly used up my 8 minutes. The court's advisory opinion is not necessarily self-implementing. Now, it may have some direct impact, and we did see some governments, the UK and Russia in particular, change their policies after the decision of the court. Russia adopted the language from the decision from the court restricting threat or use of nuclear weapons to the cases of extreme circumstance, the self-defense when the survival of a state was at stake. So there was some shift there. UK made 3 initiatives. I won't get into it at the moment. They've now gone backwards. But immediately after there was some impact. But it actually takes more than that, and that's why we worked on the follow-up UN General Assembly resolution, which called for implementation of the decision by having negotiations for a nuclear weapons convention, which would provide for the complete elimination of nuclear weapons under strict and effective international control. We followed up with the NPT Review Conference, particularly through our partnership with the New Agenda Coalition, and that was very successful in getting the 13 practical steps for disarmament agreed in 2000 at the NPT. And then there are other ways that it was used in domestic court cases successfully, like the UK Trident Ploughshares, where they got acquitted based on the decision from the court, and the Citizens Weapons Inspection Teams, which is a public action to follow up, which was quite inspiring and fun. And that was inspired not just by the ICJ opinion, but also UNSCOM. And so citizens weapons inspectors went to nuclear weapons facilities in nuclear armed and allied countries in order to monitor the compliance or report non-compliance with this law affirmed by the International Court of Justice prohibiting nuclear weapons. There's just a few photos of the citizens weapons inspectors. And then I'll finish with the inspiration now, which is that this case has given inspiration to youth around the world to launch a campaign to take the issue of climate to the International Court of Justice, and we're serving as advisors for that. Thank you very much.
Well, thank you, Alyn. I see we've had a question or two. Possibly we'll be able to take them up in the question and answer session, which will be in 20 minutes or so. So our next presenter is Daniel Rietiker. Daniel is a lecturer on international law at Lausanne University and Suffolk University Law School, and he's co-president of IALANA. He'll be talking about human rights and nuclear weapons. I had the pleasure of working with Daniel on submissions to the Human Rights Committee when it was developing its general comment. So take it away, Daniel.
Yes, thank you so much, John, for giving me the floor. Dear colleagues, dear friends and colleagues, I'm very pleased to talk in this seminar, reminding the ICJ advisory opinion, but also looking forward and talking about new issues. So I'm talking about the relevance of human rights to nuclear weapons, and I think this is one of the big developments since the ICJ rendered its opinion 25 years ago. So this is really a topic which I have written about in my recent research, not only on civil and political rights, but also on more like globally on economic, social, and cultural rights and nuclear weapons. I think there are clear evidence of the relevance of human rights to nuclear weapon issues. For instance, in the Treaty on Prohibition of Nuclear Weapons, which will be more explained in detail by the next speaker. There is clear human rights language in the preamble already. We're talking about victims of nuclear weapons. We're talking about the need to accept and respect human rights law under all circumstances. My time is limited, so I'm really going to be brief, basically on 4 issues: the added value of human rights law to nuclear weapons as a first point. A second point is the right to life in general. And the third point would be very quickly, because Christine has already talked about this, the human rights general comment number 36, which is became quite a weapon of us in the fight against nuclear weapons, and especially the fourth point, how Alyn and partners have been using this general comment so far. So first, the added value of human rights law for the use of nuclear weapons, or very briefly, a couple of points. So even so that international humanitarian law is generally more specific, sometimes called lex specialis, and has normally been considered the primary source applied to nuclear weapons, human rights law adds another significant layer to the protection of the human being. It has, in particular, the following advantages. First, human rights instruments apply basically in all circumstances. It had been said by Christine earlier. As a result, the cumbersome question for lawyers, very cumbersome questions, whether the threshold of an armed conflict has been reached in a concrete situation, does not have to be addressed, contrary to what is the case with humanitarian law, which only applies in an armed conflict. This has been said in the 1996 advisory opinion. So first point. Second point, while human rights have traditionally been considered to protect the individual against arbitrary interference by a state into protected rights, the more recent dynamic interpretation of international human rights law imposes on state parties the duty to take effective measures in order to protect the persons under their jurisdiction against harmful acts of the other persons or even private entities. This type of so-called positive obligations of the states are today well established in the jurisprudence of human rights bodies. Yes, this is my son, 2 years old. This aspect is noteworthy in the present debate because such positive obligations also exist in the field of nuclear disarmament. For example, the duty to negotiate in good faith towards general and complete disarmament, or the duty to assist victims of use or testing of nuclear weapons, or to provide for environmental remediation under Article 6 of the TP and WW. Third, the particular nature of certain human rights has also to be stressed. It is important to mention that, and here human rights law follows international humanitarian law, certain norms of human rights law have today attained customary status, therefore applying also to states not having ratified the relevant treaties. This is true, for instance, for the right to life or the prohibition of torture or inhuman or degrading treatment. Moreover, the normative supremacy of certain human rights has to be emphasized too. In other words, certain rights cannot be derogated from, which is a strong indication for their peremptory nature, so-called jus cogens nature. In addition, the obligation to refrain from a breach of such a norm is also one that is of erga omnes nature. In the case of the Barcelona Traction, the ICJ defined these obligations as obligations of a state towards the international community as a whole, adding that by their very nature, the former are the concern of all states, and all states can be held to have a legal interest in their protection. The most important consequence of a breach of an obligation of erga omnes lies, from my point of view, in the possibility of any state to invoke the responsibility of the state causing the damage, independently on whether or not that state is directly injured by such a breach. The condition for such an erga omnes invocation is that the obligation breach is owed to the international community as a whole. As a result, accepting that this nuclear attack would entail significant human rights violations, it can be suggested that if state A attacks state B with nuclear weapons, all other states would be considered having a legal interest to act on behalf of state B and could invoke state A's responsibility. Fourth, human rights treaties are formulated in terms of actual rights, individual rights, that the individual can invoke against interference in its rights by the state. Other branches of international law, including IHL, are formulated more often in terms of obligations of states owed to other parties. They might therefore not be directly relied upon by an individual. This aspect is closely linked to the probably most significant advantage of human rights law, namely its institutional dimension. In practice, victims of human rights violations, including victims of a potential nuclear weapons use, can rely on treaty bodies and mechanisms providing for legal remedies. This aspect distinguishes human rights law sharply from humanitarian law that is much less institutionalized, relying largely on the goodwill of the state parties in implementing its rules and principles on national level. To sum up this chapter, it is undeniable that human rights law has advantages that might turn out beneficial in the fight against nuclear weapons, and as a result should be used by civil society and governments engaged in this field. Second question, the right to life more generally. The right to life is the most fundamental human right. The ICJ, in its 1996 advisory opinion, confirmed, as has been seen before, the applicability of the rights to life in time of armed conflict, and moreover observed that the test of what is an arbitrary deprivation of life within the meaning of Article 6 of the International Covenant on Civil and Political Rights has to be determined in light of international law governing armed conflict, in particular humanitarian law. As has been mentioned above or before, under the ICCPR, the right to life is non-derogable even in the event of a public emergency which threatens the life of the nation. Contrary, for instance, to the European Convention of Human Rights under Article 2. The right to life seems relevant in many respects in the context of the use of nuclear weapons. Just to name 4 situations very briefly. Of course, first and the most obvious, it's the actual use of nuclear weapons, which has the potential to take the life of tens and hundreds of thousands of people within a couple of seconds, and without being capable of distinguishing between enemy and combatant and civilians, not even taking into account the high number of people who die after years and decades as a consequence of exposure to radiation. If this does not constitute arbitrary deprivation of life within the meaning of Article 6 of the International Covenant on Civil and Political Rights, what else would? The European Court of Human Rights had the occasion to deal with a situation of bombing by Russian troops of villages and towns in Chechnya, and repeated the criteria in this kind of situation in bombing, and here in fragmentation bombs. The criteria must be the operation has to try to avoid or minimize death, and should not be disproportionate. I can only summarize that from my point of view, if in case of a high explosive fragmentation bomb, the court easily find violations of the right to life, I think the bombing of a nuclear weapon on an inhabited town would even be more so a clear breach of this right. Second, it has been shown in recent research that one of the aspects that makes nuclear weapons so fatal is the fact that no adequate rescue and medical response is possible due to the complete destruction of infrastructure, the death of medical personnel, and the long-lasting radioactivity, rendering access to the area very difficult. The presence of radiation after a nuclear attack would seriously hamper the ability to search for, to rescue, and to care for the wounded. This would, according to me and other academics, amount to a violation of the rights to life by the attacking state. Moreover, the rights to life encompasses the duty to avoid or minimize loss of life, as we have seen before. civil as well as among the enemy combatants, which are hors de combat, out of actual combat. The duties inherent in the right to life do not stop there, since the state might be under obligation to provide adequate medical care in response to a harmful event. The significance of subsequent medical care to prevent loss of life, as well as the duty to investigate the whereabouts of missing persons, soldiers or civilians, have been examined in particular by the European Court of Human Rights. A concrete example is the case of Varnava and Orders versus Turkey, where the court held that in a zone of international conflict, states are under obligation to protect the lives of those not or no longer engaged in hostilities, and that this duty also extends to the provision of medical assistance to the wounded. It would be virtually impossible in the aftermath of a nuclear weapons explosion to comply with this duty. In light of what precedes, it can be argued that the right to life plays a significant role in the context of nuclear weapons, and this even long after the detonation of such a weapon. Point number 3, the general comment number 36 on the right to life, which has already been introduced by Christine earlier today. I can be quite brief on that. So on 30th October 2018, the UN Human Rights Committee, which is in charge of the implementation of the ICCPR, adopted its general comment number 36 relating to the right to life, Article 6 of the Covenant. It is in many respects a remarkable document and a new example for bridge building between nuclear arms control, disarmament, and human rights. The general comment is a detailed and lengthy document of 70 paragraphs. But for today and for our discussion on nuclear weapons, it's paragraph 66, which is the most relevant. It's remarkable to say that prior to the general comment number 36, the Human Rights Committee issued already two other general comments on the right to life. General comment number 6 in 1982 and general comment number 14 in 84. I just have it here on my slides. Remarkably enough, or surprisingly enough, the court in its advice opinion in 1996 did not explicitly refer to these documents. A couple of years ago, the Human Rights Committee began its consideration of a new general comment on the right to life. A first proposal was considered quite disappointing by our community, and together with other partners, Ayalana filed submissions in order to improve that text. And I don't know how much we had influence on that, but the last version, the final text adopted by us, is quite satisfactory, is quite remarkable. And here I just have the text without more going into detail, because a lot has already been said by Christine. Don't have the time for more. It has several components. The most general statement, the most maybe important statement is that the threat or use of nuclear weapons, because it's indiscriminate, is incompatible with the right to life and constitutes crimes under international law. First message, general message. Second message has also been highlighted by Christine. There we have really a reminder of the obligations of non-proliferation by the states parties. States parties to this covenant are reminded that we have non-proliferation obligations flowing from other international treaties and probably also from customary international law. Then, remarkably as well, another part, the states party must also respect the international obligations to pursue in good faith negotiations. Or this is Article 6 NPT duty, and remarkably as well, in the light probably of the treaty on the prohibition of nuclear weapons, to afford adequate reparation to victims who are victims of use of nuclear weapons or testing of nuclear weapons. So these are the remarkable 4 parts of this document. Just sum up on this. For me, this paragraph 66 is a very valuable statement. Perhaps the main value of this paragraph, of this general comment, from a strictly legal point of view, lies in the fact that this general comments of human rights bodies are generally considered as authentic interpretation of the relevant treaty provisions and as a result of the duties of state parties deriving from those instruments. Christine has already mentioned this, authentic interpretation of the duties. Under certain circumstances, they might even reflect customary international law, or at least as state practice contribute to the establishment of such law. It is noteworthy to mention in this regard that all states that are recognized as possessing nuclear weapons under the NPT are parties to the ICCPR, with the exception of China, which has at least signed that treaty and has also already some obligations as a signatory state. It is also remarkable that the Human Rights Committee, when adopting the General Comment number 36, was composed not only of independent experts from non-nuclear weapon states, but also of members from nuclear weapon states, namely France, Israel, UK, and the US. Now, just to mention what IANA and its partners has already done, a couple of years ago, we have submitted submissions in the so-called periodic review mechanism, especially within the Human Rights Committee. So states are assessed, implementation of states of the International Covenant of Civil and Political Rights are assessed every 5 years normally, and civil society can file observations and raise issues of their concern. And this is I just mentioned this last submission of us, which we have done in regards to France, and we have really asked concrete questions. So what, for instance, what steps will be taken to bring policy doctrine regarding the threat or use of nuclear weapons into conformity with the rights to life? Or what about the obligation to pursue in good faith negotiations? And remarkably also, I think, compensation of victims of testing by France, and reparation, question of reparation, yes, to testing of nuclear weapons. So this is just one example of quite a couple already of our submissions to feed the debate. So final remarks, more and more evidence for the increasing relevance of human rights law for the
Daniel, can we close it off there, because
yes, I let this slide on.
You let the slide speak for itself.
Exactly. So we can distribute it later. So thank you so much.
Thank you, Daniel. And let me now ask Manfred Mohr to make some comments on this topic of human rights and nuclear weapons. Manfred is a professor of international law, having taught at Humboldt University, Berlin, and other universities. He has been a Red Cross specialist in international humanitarian law and is a member of the board of German IALANA, as well as a co-founder of International IALANA. Manfred.
Thank you, John. Really, just a few comments, something to be added to this presentation by Daniel. One is on the general comment of 1984. It is important that this comment refers to the danger stemming from nuclear weapons in the case of error or failure. So this is a very important point also for the anti-nuclear weapons campaigning, saying the mere existence of that kind of weapon is a danger to mankind and a danger to the right to life. Then Daniel described in extenso the great potentials of human rights law in arguing against nuclear weapons. This refers to substance, and it's much more than the right to life alone, which is the cornerstone, of course, but also other human rights, such as the emergent human right to a clean and healthy environment that may come into play. And the second direction, it's the procedural strength of human rights law, already described by Daniel. And I would like to refer now to special procedures of human rights law or of the human rights system, like the procedures of special rapporteurs of the Human Rights Council, or the special procedures themselves, referring to victims of human rights violations. So there has been fact-finding mission by the Special Rapporteur on Toxics to the Marshall Islands in 2012, which was quite effective, at least politically speaking, in a way, in contrast to court proceedings. So my experience, or our experience, also working against uranium weapons and ICPU, another coalition, that is sometimes better not to go to court, but to look for less expensive, less complicated procedures like these human rights procedures. And they are available as electronic files. So it's very simple to fill in these forms and make a click and send them to Geneva. Here they are within the United Nations system of human rights protection. So altogether, I would like to repeat and support and reinforce the multifaceted approach to nuclear weapons, which is already in the ICJ advisory opinion, but this is an approach that we repeated time and again. It is not only IHL that counts. It is not only human rights law, which is so important, that counts. It's not only environmental law. It's a complex of all these law branches that have to be used as arguments in our campaigning, our legal work. And here, which needs some more research and also argumentation, maybe this lex specialis rule or lex specialis principle, which was important for the ICJ to then focus on IHL alone in the end, this lex specialis rule maybe not so be important anymore, but we have to see these branches all in parallel and work with them together as a complex, legal, substantial and procedural approach. So this is just to sum up also my personal experience in the fields of fighting against nuclear arms, uranium weapons, and other kinds of horrible armory we have. So yeah, that is just this small comment I would like to make on what Daniel and others have said. Thank you.
Thank you, Manfred. Very, very stimulating. We'll have to think about, for example, use of special rapporteurs. So I think we'll skip the Q&A session in the interest of time, and we have one scheduled for later, and hopefully we'll be able to do that one. We now have a video message from the Japan Association of Lawyers Against Nuclear Arms, Kenichi Okubo, the president of JALANA. Can you play that, Lucas?
イランに結集する核兵器のない世界を目指す同志の皆さん、日本反核法律家協会を代表して連帯のメッセージを送ります。今年1月22日、核兵器禁止条約が発効しました。日本反核法律家協会は条約の発効を心から歓迎するとの声明を発しました。この条約は被爆者の長年の願いに応えるものであるし、核兵器も戦争もない世界を実現する上で画期的な一歩となるものだと評価しています。1945年8月、その年の12月末日までに、広島では14万人、プラスマイナス1万人、長崎市は約7万4千人が死亡しています。1944年2月時点での広島市の人口は33万6483人、長崎市は27万6003人でしたから、その死亡率は広島市が 41.6%、長崎市が 27.4% となります。その地域の 40% が1年以内に死亡する事態は人類史上ありません。原子爆弾の非人間性は明らかです。皆さん方は人影の石をご存知でしょうか。銀行の石段に腰をかけ、回転を待っていた人が原爆の閃光を受け、逃げることもできないままにその場で死亡し、強烈な熱線により石段の表面は白っぽく変化し、その人が腰掛けていた部分が影のように黒くなって残ったというエピソードです。広島の原爆資料館に展示されています。原爆はこのように大量無差別残虐に人々の生命と 日常を奪ったのです。加えて、原爆放射線は今日まで被爆者の心身を苦しめています。戦争の終了は原爆被害の収束をさせることはなかったのです。だから被爆者は人類と核は共存できない。被爆者は私たちだけにしてほしいと訴え続けてきたのです。日本の法律家はこの被爆者の思いに応えようとしました。アメリカの原爆投下の違法性を問う原爆裁判を提起したのです。1963年12月、東京地方裁判所は米国の原爆投下は国際人道法に違反するとの判断をしました。その判決はシュノドケースとして国際法に影響を与えました。その裁判の原告代理人の一人は日本反核法律家協会の初代会長、松井康弘弁護士でした。1994年8月、松井たちは日本反核法律協会を設立しました。私たちはそのことを誇りに思っています。さて皆さん、1996年7月、国際司法裁判所は核兵器の使用の威嚇は一般的に国際法に違反するとしました。けれども、国家存亡の危機における核兵器の使用や威嚇については違法と断定しませんでした。被爆者は例外的とはいえ、核兵器の使用や威嚇が容認される余地を残すことの結論に賛同しませんでした。けれども、禁止条約は核兵器の使用や威嚇にとどまらず、開発、実験、製造、保有、従事など、核兵器の存在そのものを違法化し、その廃絶を展望しているのですから、ICJ の勧告的意見の見解を乗り越えています。であるがゆえに、被爆者は禁止条約を心の底から歓迎しているのです。そして私もその被爆者に共感しています。勧告的意見は次のように言いました。核兵器の特性を考えれば、武力紛争に適用される法とほとんど両立できないように思う。しかしながら裁判所は核兵器の使用が武力の紛争に適用される法に必ずいかなる状況においても矛盾することになるという結論は出せない。なぜなら国家の生存という基本的な権利を度外視できないからである。そして国連憲章51条の自衛に訴える権利を度外視できない。国際社会のかなりの部分が長年にわたって依拠してきた核抑政策といわれる慣行も無視することはできない。ここでは自衛の手段として核兵器と核兵器による抑止が語られています。端的に言えば国際法の世界で核兵器が容認される余地があるという発想です。また核兵器が国際社会に平和と秩序をもたらしているという言説に理解を示すかのような議論です。私は ICJ の勧告的意見のこの部分を超越しなければならないと考えていましたが、禁止条約は条約国際法として ICJ のこの限界を乗り越えたのです。禁止条約は核兵器に依存する国家の自衛権や抑止力を否定したのです。ミュラマントリー判事が少数意見の中で述べたあるべき法が現にある法とされたのです。国際人道法上の画期的転換がもたらされたのです。私は禁止条約が実現した背景には、被爆者の運動をはじめとするさまざまな反核平和運動があったし、イヤラナも関与しているモデル核兵器条約の存在も大きく寄与していると考えています。私はイヤラナの一員であることを誇りに思っています。私は禁止条約発効後の私たちの任務は、まず第一に自国政府に禁止条約への署名批准を働きかけることであると考えています。イヤラナを構成するメンバーの母国で署名批准している国はコスタリカとニュージーランドだけです。日本の政府は TPL の禁止条約は国民の命と財産を危険にさらすとしています。米国や NATO 諸国も禁止条約を敵対しています。私たちはそのような自国の政府の姿勢を変えることから始める必要があるでしょう。その際に念頭に置いておきたいことは、核不散条約6条は、各締約国は核軍備競争の早期の停止、および核軍縮に関する効果的な措置につき、並びに厳重かつ効果的な国際管理の下における全面的かつ完全な 軍備縮小に関する条約について誠実に交渉を行うことを約束するとしていることです。6条は核軍備競争の停止、核軍縮にとどまらず、完全な軍備縮小に関する条約の誠実な交渉を義務付けているのです。ICJ 勧告的権は6条について、厳重かつ効果的な国際管理の下において、あらゆる点で核軍縮に導く交渉を誠実に遂行し、かつ完結させる義務が存在すると全員一致で結論していました。交渉の遂行だけではなく、その完結も勧告していたことを想起しましょう。国連加盟国は193カ国、NPT 加盟国は191カ国です。2010年の再検討会議では、核兵器の完全廃棄が核兵器の使用あるいは使用の威嚇に対する唯一の安全保障策であることを再確認すると合意されていたことを忘れてはなりません。国際社会は核兵器のない世界に向けて着実に変化しているのです。ところで、日本反核法律家協会は核兵器だけではなく戦争のない世界を求めています。核兵器禁止だけでは通常兵器による武力行使がなくならず、武力行使が容認される限り、最終兵器である核兵器の依存はなくならないからです。核兵器への依存が続き、核兵器が存在する限り、人類は壊滅的人道上の結末から免れることはできません。私たちは核兵器の違法化と廃絶を求めるのであれば、戦争の廃棄と戦力一般の廃棄を展望しなければならないのです。それは論理的必然です。日本国憲法9条は戦争放棄、交戦権の否認、戦力行使という徹底した非軍事平和主義の規範です。それは次の大戦は核兵器を用いての戦争となり、人類社会の滅亡をもたらすので戦争をなくさなければならない。戦争をなくすのであれば戦力が不要になるとの論理でした。戦争違法化をさらに進め、戦力の放棄を規範化したのです。日本反核法律家協会は、核不拡散条約を補完する禁止条約の普遍化を求めるだけではなく、日本国憲法9条の非軍事平和主義の規範を世界化、普遍化して、一日も早く核兵器も戦争もない世界を実現するように、被爆者をはじめとする平和を愛する諸国民の公正と信義に信頼して、引き続き努力することを誓うものです。ありがとうございました。
So it is impressive the effort that Jelana has made to provide us videos. So if any of you are listening now or later, thank you very much. Next, Amela Skiljan will be speaking. She'll talk about the Treaty on the Prohibition of Nuclear Weapons. She is vice chair of the German affiliate of IALANA and a member of the IALANA board. She studied law in Bosnia and then earned a master's degree in international and EU law in Germany. She is currently a PhD candidate at the University of Bremen. Go ahead, Amela.
Thank you very much, John. I'm very happy to be here, part of this event. And I have to say, just as a short disclaimer, you might hear background noises from my son too. So, yeah, the TPNW is the youngest instrument against nuclear weapons. It was adopted 4 years ago, and it came into force this year in January. This is a treaty where civil society played a huge role, and it still does. It was the civil society that initiated it with a special focus on the catastrophic humanitarian consequences. We just heard from our colleagues from Japan what these consequences were and still are in Hiroshima and Nagasaki, but this also applies for all sites where nuclear tests have been conducted. However, technology changes and advances, and so are the consequences. In 2006, a group of scientists conducted a study examining the consequences of a regional nuclear war between India and Pakistan. The hypothesis was that around 100 bombs were dropped. bombs were dropped. And here you see what the result would be. This animation actually shows the time less than 2 months after the bombs were dropped. You see how the dust spreads and covers the face of the Earth, causing a nuclear winter that would last for 10 long years. That would certainly change the life on Earth, and it's not certain that humankind would survive it. So led by these consequences, the treaty repeats in its preamble its concern about the catastrophic consequences, but it also recalls the ethical imperatives for nuclear disarmament. This approach is not new. The advisory opinion also calls these weapons as deadly, or describes or says that they cause untold human suffering, and it describes their ability to cause damage to generations to come. This is why it concludes that they are scarcely reconcilable with international humanitarian law. You see here that the preamble also points out that a detonation can be done by an accident. And I won't repeat anything what Manfred said. So moving on to how it relates to existing law, because it builds on existing law and it reaffirms it. Especially here, the ICJ's advisory opinion, it repeats the principles and rules of international law, and it reaffirms that any use of nuclear weapons would be contrary to the rules of international law applicable in armed conflict, in particular the principles and rules of international humanitarian law. Furthermore, the TPNW cites in its preamble the ICJ's conclusion regarding the disarmament obligation, seeking to advance it. This obligation is also enshrined in Article 6 of the NPT, which we have seen already. So while the states negotiating and adopting this treaty were taking this obligation very seriously, nuclear weapon states and their allies chose to neglect it. So the TPNW can be regarded as a partial fulfillment of this obligation, but not complete, as the obligation requires complete nuclear disarmament. Another place where the TPNW refers to the NPT, you can also see it on this slide. It's still in the preamble, and it refers to it as to the cornerstone of nuclear disarmament and the non-proliferation regime. And now moving to the provisions from the preamble. The TPNW reinforces existing law applying to the threat of use and the use of nuclear weapons. If you look at the first draft of the treaty, you will miss the threat of use. And I know that John was very active in adding the threat of use into this prohibition. So thank you very much, and everyone else who was involved in that. Also, the TPNW reinforces the prohibitions of the NPT. So here you can see Article 1, which contains the prohibitions or the negative obligations. And the orange highlights the prohibition from the advisory opinion, and the blues, the NPT's prohibitions, though the light blue highlights the prohibitions for the nuclear weapon states and the dark blue for the non-nuclear weapon states. And just a small remark to the prohibition of assistance, encouragement, and to induce. The NPT refers only to manufacture and acquisition. So the TPNW goes beyond all prohibitions of the NPT, and also in this regard. And it, of course, doesn't create this two-state system as the NPT. So the prohibitions are meant for all states. This can be an example how this assistance prohibition would be under the TPNW is that a state party to the TPNW may not induce a nuclear armed state, which would then be outside of the treaty, to threaten or to use nuclear weapons on its behalf. This could be crucial for the nuclear umbrella states in practice. Or if you look at letter G, you can see that this treaty has the potential to end nuclear sharing, always under the condition that the states exceed the treaty. But this is not the end, not yet. The TPNW reinforces the prohibition of nuclear weapons contained in agreements for nuclear weapons-free zones. I only have here 2 examples, the Treaty of Tlatelolco and Rarotonga. So this list is not exhaustive. But I think it can give you an overview how the TPNW relates to other legal instruments that are trying or outlawing nuclear weapons. This is exactly what Manfred was talking about, taking a multidisciplinary approach in the fight against nuclear weapons. You see also here the obligations, so not only the prohibitions. For example, the victims' assistance and environmental remediation, which is one of the biggest achievements of the treaty, but still the principles for it can be found in human rights law or international environmental law. And not to take too much time, I just want to stress that the TPNW strengthens these norms. It is definitely contributing to the delegitimization process of possession, of development, of manufacture of nuclear weapons, but also nuclear weapons in general by combining all these legal aspects with a humanitarian and an ethical approach. The TPNW is an important piece in this patchwork of legal instruments that fight against nuclear weapons, to declare them illegal under any aspect and under any circumstances once and for all. And finally, as Article 4 of the TPNW is entitled, towards the total elimination of nuclear weapons. This is our goal. Thank you very much.
Thank you, Amela. And I think it's a very interesting project you have going, analyzing the way different norms, different obligations are situated in the TPNW and other legal instruments. I think we'll go into a brief Q&A here, but I first want to say something myself, which is that I think the TPNW I think that the TPNW is a marvelous statement of the moral, political, and legal norms that should guide the abolition of nuclear weapons. I think it made a very big contribution by bringing in obligations as a matter of treaty law of victim assistance and environmental remediation. But I also want to say that there are several possible paths towards a nuclear weapons-free world. TPNW is one of them, but in my view, the TPNW will have made a contribution just by stimulating, focusing again on how you go about achieving the non-use and elimination of nuclear weapons. So we are nearing the end, and I think I will just ask one panelist, and that is Alyn Ware, to answer questions that have been raised about what are the lessons of the advisory opinion on nuclear weapons for a possible advisory opinion on climate justice, and perhaps that it's appropriate that we discuss this because many of us think it's important that we link the cause of nuclear disarmament to other important causes. So go ahead, Alyn.
Thank you very much, John. I'll just take two approaches to this. One is on the legal precedents and the other is on the campaign precedent. Legal precedents, I've just put in the chat box an article which I wrote, which was looking at the reference to environmental law and particularly law protecting future generations in the ICJ advisory opinion of '96. And that is something which has stimulated interest of the world's youth for climate justice, you know, the fact that this is not the only time that the International Court of Justice has highlighted environmental principles, sustainability principles, precautionary principle, and protection of future generations. But it's in the 1996 advisory opinion. So that's, as I said, is one of the things which has stimulated World's Youth for Climate Justice, supported by the Normandy Chair for Peace, which is like a French think tank, to launch an initiative to start a campaign to get the issue of climate to the International Court of Justice, the climate, and particularly, you know, the responsibility to have a sustainable climate to protect future generations. The second part, which is inspiring them, is the fact that we managed to do it. That we took a case which was against the most powerful countries in the UN system. You know, the P5 members, the permanent members of the Security Council, all were against us, plus all the allied countries were against us, and yet we managed to get a successful resolutions through both the World Health Assembly and the UN General Assembly, but the UN General Assembly is the main one. This has given a lot of hope for the youth, our World Youth for Climate Justice, as I said, who started this, to think that, oh, it's possible that they could get the General Assembly to take a case to the International Court of Justice. So those two parts, I think, of you know, these precedents are really helpful to this really exciting initiative of the youth to take a case on climate to the International Court of Justice.
Well, thank you very much, Alyn. And right on time, I'm going to turn the proceedings over to Fawn for some closing remarks.
Well, thank you, John. Let me stand up. Thank you, John. Thank you, Amela, Alyn, and Daniel for this afternoon, the second session talks. I always think about the question on what additional ways can the law be supportive for the struggle against nuclear weapons, and more importantly, for the struggle toward nuclear abolition. And I am recently, which is the last couple of years, rather positive about a thing that Daniel came with when he joined IALANA, and that's a topic he talked about this afternoon. That's human rights in substance. And why is that? Because the Human Rights Convention, the Human Rights Covenant, better, of the UN, is a very widely ratified treaty with the lowest threshold possible sort of mechanism to hold states accountable for violations of human rights in a very broad sense, that is. And I've been involved in other strands of human rights litigation, which also had an avenue to the UPR mechanism, the Universal Periodic Review mechanism of the Human Rights Council. And I think that one of the attractive things of using that mechanism is that from our perspective, there are too many states that are either possessing nuclear weapons or are linked to nuclear weapon states like the NATO states are, that almost in every sequence of the UPR system, there is at least one state who is one way or the other linked to the possession of nuclear weapons. And that provides us with as many possibilities to keep raising the issue and not in the same words, not keep repeating everything, although repeating is a value in itself, because it sometimes takes a lot of repetition before people start to understand what's going on, but also to reinforce our arguments and to see what the Human Rights Council does with our arguments and how we can improve the arguments if need be the next time. And I think Amela's work in trying to improve the overview of all sorts of human rights documents could be very helpful to that as well. So I think that is one of the avenues that Ayalana will work on, and it's a promise to all non-lawyers, NGOs, that we will do that. And if others need our to borrow our knowledge, we are ready and available for that. And I think that's one of the perspectives for us. The other one keeps coming back to me also, and that is, when are we returning to the International Court of Justice? Because we want to have this clarification on the last part of its advisory opinion with respect to the general obligation, general or not obligation, to negotiate and conclude nuclear disarmament. But there are many other questions that could be part of that. And I think there is some work to do there as well. It may even be an avenue to merge the efforts done by the treaty ban people and people like us from Ayalana, because there is a lot of overlap between what we are doing and what the ban treaty, what ICANN is doing. And of course there is overlap because we're all in there for the same goal, to struggle for a world without nuclear weapons. I found our first webinar to be very interesting. I've seen loads of things that we're going to work on to improve, but let us know what you think about this approach. If you have questions that come up tomorrow or during the weekend, don't hesitate to send them to us and we will get back to you. And if we have next versions of the webinar, we will get back to you too. Everybody that has been participating until now, still 78 people in total right now, which I think it's a considerable amount of people. Do tell your friends that this session has been recorded in its entirety and that we're going to make it available in parts and bits and parts of the various speakers soon. Information about that will be on our website shortly. Thank you very much for participating, and I hope to see you back. Well, what's to see you back? To see you back soon. Thank you.